الحمد لله رب العالمين حمدا يوافي نعمه ويدافع نقمه ويكافئ مزيده فيا رب لك الحمد حتى ترضى ولك الحمد بعد الرضا لك الحمد كما ينبغي لجلال وجهك ولعظيم سلطانك سبحانك لا نحصي ثناء عليك أنت كما أثنيت على نفسك فاللهم أخرجنا من ظلمات الوهم وأكرمنا بنور الفهم وافتح علينا بمعرفة العلم وسهل أخلاقنا بالحلم واجعلنا مما يستمعون القول فيتبعون أحسنه اللهم اجعل أعمالنا خالصة لوجهك ولا تجعل فيها حظا لغيرك يا مقلب القلوب ثبت قلوبنا على دينك آمين والسلام عليكم ورحمة الله وبركاته. How's everyone? الحمد لله رب العالمين. طيب. So we get straight into it, inshallah. We're still reading Islamic Contract Law. And what has passed with us thus far, I think this is the 5th class. And what has passed with us thus far is that we remind ourselves once again that we are studying Islamic Contract Law and we're not studying Islamic Finance. And those are two separate things. So when we look at Islamic Contract Law, we speak about the underlying contracts that govern the exchange of wealth, right, in the form of goods and services between people. In this, we said that there are many types of exchanges. We will be looking at one exchange, and that is the exchange of a physical commodity for another, known as the simple sale or the conventional sale. For the conventional sale to have its effects, and the effects is that the transfer of ownership takes place. In order for this to have its effects, then certain arkan, certain components must exist for the sale, certain integrals must exist for the sale, and those integrals must exist meeting certain conditions. When this happens, then the ownership, the exchange of ownership takes place, and you have a sale. And we said that this consists of the contracting parties, which is the buyer and the seller, the contracted item, which is the commodity and the counter value, and the formula, which is the offer and the acceptance. Thus far, we discussed the contracting parties and we spoke about the conditions for the contracting parties. We said that there must be unrestricted contractual capacity, and we explained what that means. We also said that there must be the absence of coercion without just cause, and we explained what coercion is, types of coercion, and what does it mean for coercion to take place without just cause, just as we explained in relation to that the matter of al-akhdu bil-dhafar, right, if you remember that. Then we said that there are certain conditions which are specific to certain buyers on account of the product that they're buying in the form of the Quran and the like, that buyer must be Muslim. Then we also said that sometimes it is that there is a quality within a buyer, and that will bar us from selling them certain commodities, such as the buyer being at war with the Muslims or in a state that is at war with the Muslims, so we will not sell them weapons, and that sale will not be valid, right? Then we said that just as the contracting party can enact the sale himself, so too can he appoint an agent to enact the sale on his behalf. When he does so, choosing an agent or a proxy, then we stipulated that the same conditions which must be met for the contracting parties in the form of the buyer or the seller must exist in his agent. Then from there, we said, via an a fortiori argument, if you want to, that if it is that the Sharia will allow a human proxy, then more appropriately, the Sharia should allow a program proxy in the form of a vending machine and the like. Then we moved on to the contracted item, and we said that in order for the contracted item to validly take part in a sale, in that it can be exchanged between two people, such that the ownership is transferred, it must meet certain conditions. The first of those was purity, and we mentioned that something must be pure in terms of its essence, in that the Sharia considers that thing to be pure. As for the case where that thing is sullied and can be cleaned, then we said that the Sharia will allow us to sell that. Then we said that something must, and obviously we spoke about the Hanafi madhab in that regard, right? Then we said that something must have a utility. And when it came to a utility, we said that the first measure for something having a utility is a physical measure. So something must have a physical utility, right? Then we said that when something has a physical utility, we will have to check whether or not the Sharia permits us to access that utility. If the Sharia permits us to access that utility, it can be sold. If the Sharia does not, the like of a musical instrument, then it cannot be sold, right? And that would have been the last thing that we discussed over there. So we move over to the third precondition. And the third condition for the contracted item, and we're on page number 30, is that it be possible for the contracted item to be handed over. At times, we find that the seller owns that which he wants to sell, but he's unable to make over the commodity to the buyer. That the seller is unable to hand over the commodity is either due to a tangible cause, such as the loss, theft, or usurping of the commodity, or an intangible cause, such as the commodity being placed as a collateral. As such, the creditor's right prevents the debtor from selling the collateral. So what is this condition talking about? It's howling there. So what is this condition talking about? This condition is saying what? It must be مقدورا على تسليمه or مقدورا على تسلمه. It must be possible for the seller to take possession of it. To take possession of it. Right? So this is different from actually taking possession of it. Right? So you have two words. You have the word potentially and you have the word actually. Right? So what we are speaking of here is that this item can potentially be handed over, even if it's not actually handed over. Right? For example, I have this book, Naf'ul Asqa. I want to sell this Naf'ul Asqa. Right? So this book is here. I can sell this book to any one of the attendees. Why? Because it will be possible for me to hand it over to them. There's nothing preventing me, neither normatively or physically, nor legally, right? This is not placed as a collateral anyway, right? And nobody has usurped it from me. Therefore, it will be possible, potentially, for me to hand it over. We could conclude the sale. I sell this book to Imad for 200 rands, right? Imad gives me the 200 rands, and he says, I'll fetch the book later. So here you have a case where it's potentially possible for me to hand it over, though physically or actually it was not handed over, the sale is valid. You get another case where it is not possible for the thing to be handed over. For example, let's consider the same book, right? Let's imagine that this book has been usurped. You know what usurped means? Somebody takes it from me against my will, and I know that I have it. So let's say Ibrahim has it. Okay, not Ibrahim. Let's say there's a person, his name is Mark. So Mark has the book, right? And I see Mark walking around with the book, except that I don't have the capacity to get that book back from Mark, but it's my book. So in that case, I can't sell the book. Why? Because it's not possible for me to hand it over. You understand that? There's no potential for me to hand it over. What of the case where Ibrahim comes along and he says, Mark, I'll take Mark. Meaning what? I'll whack him. So Ibrahim says, look, I'll buy it from you. I have the capacity to take it from Mark. Over there, we'll allow him to buy it. Why? Because now I found a buyer whom, through his strength, the condition for the potential of that thing to be handed over has been met. You understand that? As for the case where that's not possible, then I cannot sell it. You understand? So that is when something physically, on account of a normal reason, cannot be handed over. There could also be a case where you could be legally prevented from handing something over, right? For example, let's say I want to buy a phone, right? I want to buy an iPhone 14. So I buy this iPhone 14 from Zaid, right? But I buy it from him at a credit price. So he tells me, wait, you got the iPhone 13 there. Place your iPhone 13 as a collateral, meaning as a security, so that if you don't pay, I can sell this and squeeze some part of it, right? Or place something more expensive, I don't know, your motorbike, for example. I don't know if a motorbike will be more expensive then, right? Place your motorbike, for example, as a collateral, just in case you don't pay it, then I can square it, right? So that motorbike over there, it belongs to me, right? And it's possible for me to hand it over physically, but I will be prevented from selling it legally. Why? Because it's tied into the right of the creditor. And once I've squared the debt with the creditor, then I can sell that thing. So there's an example where it's physically possible, but legally I'm barred from doing so. You understand that? So that is the precondition of it must be possible that the contracted item be handed over. Some. Mm. No, I understand what you're saying. I'm just thinking in my head, I wish I didn't use the word potential. Because the word here in Arabic is maqdur, and it comes from the word qudra. And qudra, the power to do something, is measured in capacity to the power that something is needed to do something. Sounds like a math equation. Isn't it so? So, in order for me to lift up 20 kgs, I must have the power to lift up 20 kgs. In order for me to get my phone back from a gangster that lives in Manenberg, I must have the power to get my phone back from a gangster who lives in Manenberg. So, where does the potential go back to? The potential goes back to the situation. So, that will be judged on a case-by-case basis. You understand that? Will be judged on a case-by-case basis. So, the judgment of the capacity to hand over will go back to the norm. Will go back to the norm. So, normatively, is it possible for me to get my phone back from Mark? It could be in relation to one person, no. In relation to another person, yes. If it's possible, then yes. If it's not possible, then no. Right? And that possibility is judged by the norm. So we mean that at any given moment, if I wanted to, I could have gone and fetched it and handed it over. If that's not the case, in that upon demand, I cannot deliver, then it's not possible. Then I cannot do so. Right? And I want us to differentiate over here between the possibility to hand over and the existence. You understand that? So over here, we're not speaking about if we say that it is not possible to hand over, we do not mean that the thing doesn't exist. That's a separate conversation. We do not mean that the contracted item doesn't exist. For example, I sell you an iPhone 14, but I'm still going to procure it. So it doesn't exist. So here you can't say, you can't hand this over to me, it doesn't exist, and you can't hand something over that doesn't exist. You say, you know what? We studied Aqidah last year in the Atikaf. This year is business. So, right, take off your Aqidah hat. We're not speaking about existential matters. Here we're speaking about normative matters. You understand that? So, when it comes to the contracted item being non-existent, then we speak about a different contract. Salam, forward buying. Is it clear? طيب. So, no question now. So, like our teacher would say to us, as-su'alu ba'da ad-dars. So many things will become clear in the course of us explaining. There was a point that I wanted to mention on this. Okay. A last extraneous example is that what if I have a bird, right? And the bird is flying in the air. Can I tell you? I tell you that bird flying in the air. Hmm? It's my bird. It's flying in the air. I can't sell it to you. I can't sell it to you until that bird is in my hand. You understand that? So this is the idea. This is the idea. It must be possible for you to hand it over, right? And when that bird is in the air, there's an unpredictability about whether that bird will come back or not, even if it normally comes back. You understand that? Type. So it must be possible for you to hand it over. The fourth condition is that the contracted item be owned by the contracting party or the one on behalf of whom he is contracting. Right? One who sells that which he does not own at the time of contracting and is not a legal guardian nor appointed as a proxy is called a fuduli. Right? It's called a fuduli. And his sale is not valid. So fuduli sales refers to when you sell something that is not yours, right? Or it does not belong to the person on behalf of whom you are selling. You understand that? So you have two people. You have Zaid and you have Amr, right? So Zaid has got, let's say Zaid has got a phone. And Zaid appoints Amr to sell that phone, right? So what we mean is that either the phone is Amr's, he sells it himself, or the phone is Amr's and Zaid is selling it on his behalf. So it must either belong to the one who's selling it or the one on whom's behalf you are selling it for. Does that make sense? طيب. If a person sells something and it does not belong to them or the person for whom they are selling it, that sale will not be valid. You understand that? A common example of this is that sometimes, let's say for example, you go to the parade. You know the parade? The parade, you know the grand parade? Right? You go to the flea market in Museumburg. Right? Now you go there, your friends selling there. I'm sure each of us have a friend at the parade, right? That sells one friend from Darna, inshallah, mashallah, kill me them. Yes. So now you have a friend, he sells some things at the parade. So he says, look, I want to go to the toilet quickly. Can you watch my stall? So he doesn't commission you to sell, he commissions you to watch. Now a person comes, they're checking out the goods, whatever. So how much is this Avianas? Now you think to yourself, hey, we're selling it for 200. But the last time I saw they were selling it for 300 then. Access Park, okay, maybe it's 300. To be safe, I say 350. Sell it, right? If the 50 rand, if it's 300, then I'd keep the 50 for me. So whatever, right? So now you enact the sale. You enact the sale and you sell it for 300 rands. 350 rands. You sell it for 350 rands, right? Out of precaution. Right? Your friend comes back. Where's this pair of Avianas? I sold it. Sale valid? No. Sale valid? No. Why? Because at the time, he didn't commission you to sell. He commissioned you to do what? To look after his goods. Right? Then scholars will go different ways. Some scholars will say that even retrospectively, the sale will not be validated. Other scholars will go to say what? That if retrospectively he okays the sale, then the sale is okay. Right? Other scholars will go a third way and they will say that if at the time he knew that the person would have wanted him to sell it, then it will be valid. Right? But the jadda, the position of the madhab is what? Is that sale will not be valid. Right? So remember the fuduli. Remember the fuduli. Because the fuduli, when we discuss murabaha, a type of home financing that is found in Islamic finance, we'll discuss it when we get to loans, right? Then the fuduli will play an important role in scrutinizing that contract. So remember this. طيب? So that's the fourth condition. Everybody still with us? So the fifth condition is that every aspect of the item, of the contracted item, be known. By this we mean that the corporeal specifications and quantity of the contracted item is known. Anything that causes the contracted item's corporeal, you still remember the meaning of the word corporeal? The corporeal is the thing itself. And the usufruct is the benefit that is derived from that thing. Right? So the corporeal, the physical thing must be known. Its specifications must be known, and its quantity must be known. Anything which causes the corporeal, the specifications, or the quantity of the contracted item to be unknown, right, or prevents the ability for that to be handed over, is called gharar. It's called what? Gharar. And gharar we have chosen to translate here as contractual risk. And a sale in which there is contractual risk is invalid. You understand that? The Prophet ﷺ, he prohibited gharar, contractual risk in sales. طيب. So now we're going to take this fifth condition and we'll break it up. We'll speak about knowledge of the corporeal in general. We'll speak about knowledge of specifications, and we'll speak about knowledge of quantity. To give a short example, let's say I want to sell you a car. So either the corporeal is specified physically. So I say what? I sell you this car. If the car is in front of you, and I say I sell you this car, the sale will be valid. Without having to verbally specify it. You understand that? If the car is in front of you, right? Then you take a look at it. And then the next time the person says, I sell you my car. Right? And it's from such a category of goods that would not normally change in that period of time, then the sale will be valid. Right? If it is something that changes, then the person will have to specify. The person will have to specify. So we'll have to say, I sell you a Toyota, it's a Camry. He will have to tell you the year model. He'll have to tell you whether it's automatic or manual. He'll have to tell you whether it's a 5-door or whatever the case might be. Right? And then he will have to tell you the quantity. So that's the specifications. Then, are you selling one car or are you selling two cars? Right? Are you selling one bar of soap or are you selling a box? You understand? The person will have to specify the quantity. So sometimes maybe you're selling basmati rice. So you have to say, look, I'm selling you 1 kg of basmati rice. I'm selling you 2 kgs of basmati rice. So sometimes it's by counting and sometimes it's by measurement. If it's something that is counted, then the units must be mentioned. If it's something that's measured, then the measurement must be measured. Right? So you don't say, I sell you 1 kg of phones. It's not something which is measured, something which is counted. You understand that? So that won't be valid. That won't be valid. You understand that? طيب. So now, Marana gives an interesting thing. What does he say? The contracted item must be specified, the corporeal. It is thus impermissible to sell one of 2 cars if the exact car is not specified. Remember this, O seeker of success and salvation, for indeed it is important. So if you have 2 cars before you, they tell you, take any car, it's yours. Meaning, or say, I sell you any car. Maybe there's 3 cars in front of you. You're standing in the person's garage, mashallah, he's got 3 nice cars, 3 vintage cars. Says, any one of these cars, I sell to you for $1 million. The person says, I accept, and they go home. Is the sale valid? No. Why? Because the car is not specified. Because the car is not specified. And you see, most of the time, when there's non-specification, it leads to niza'. It leads to what? It leads to contention and dispute amongst the contracting parties. Now he comes back the next time, and then he chooses the, give us a vintage car there, man. He chooses the Beetle, mathalan, is a Beetle vintage? Or is it old? Right? We chooses the Beetle. The person says, no, 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 not the Beetle, not the Beetle. You see the problem? Non-specification. So from the offset, we're going to say that contract was not valid, right? So the person will have to specify it at the time. If the person says, I sell you any one of these 3 cars for $1 million, and then the person says, I accept the purchase of the Beetle for that price, then it's valid. Right? So it can start out non-specified and end up specified. We'll consider it valid. You understand that? Fine. So here's an example. You might enter a shop or marketplace and find that the sales basket is filled with, by way of example, shoes at a reduced price, with a sign on it saying that you can take any one or 2 for a specific price. You notice here that the price is specified. As for the commodity, at first glance, it seems that it's unspecified. What is the ruling regarding the sale? Right? So you go there to non-boycott store. Crocs. We're not boycotting Crocs, huh? So you go to Crocs. There's normally those baskets, right? So they tell you can take any 2 for a price. So that's unspecified. Isn't it so? It's unspecified. Because the basket is there. There's a whole lot of different shoes in. They're telling you can take any 2. So it's unspecified. So what's the ruling regarding this? So he says, I say, and success is with Allah, that as long as the commodity is in the sales basket, it undoubtedly remains unspecified. However, when you remove what you want to purchase from that basket, or to use more precise terms, when you choose 1 or 2 pairs of shoes from the basket, the commodity becomes specified by your action, your extraction or choice. In this way, the commodity becomes specified. Right? The ruling is based on the fact that generality is a phenomenon that applies to words and not actions, as actions are intrinsically specific. This is a Lughawi / usuli thing, right? It's a linguistic / Islamic legal theory thing, where the nature of words is that they're open to generality, but the nature of actions is that they are specified. You understand that? So the moment you do something, you have to do something to something specific. You can't hit something non-existent or unspecified. Must be specified, right? What is important is that the commodity be specified at the point of sale. In our example, the contract is yet to be enacted, meaning he's got it in his basket, but the contract isn't yet enacted. It only takes place and is enacted most commonly when the commodity is presented to the seller or his proxy, right? So the seller is either Crocs or the person who works for Crocs, the proxy, before the customer leaves the shop. And at that point, it is undoubtedly specified. So by the time you put it on the till and the cashier rings it up, most certainly it's specified. You understand that? Type. So that's the specification of the corporeal, right? Of the physical commodity. Now we come to knowledge of the specifications and the quantity. Okay. So we gave the example of the Toyota, and that is understood. So I'll just read this. Note, it is stipulated that the contracted item be described when it is not present at the time of contract. As for the case when it is seen, there is no need to describe it according to our school of thought, as will be explained and discussed in due time. طيب. So listen to this. Stipulating that the commodity be described over here is in relation to that which is actually physically absent at the time of sale. So we say that you only need to describe something in detail if it's not there. If it's there, then you can just say, I sell you this. He says that, so should we not stipulate the same when there's a myth? He says, stipulating that the commodity be described over here is in relation to that which is actually physically absent at the point of sale. So should we not stipulate the same when there is a metaphorical absence, in that it is veiled from sight whilst the commodity is present? What's Malna saying here? That sometimes you might have a product that is physically present, but it's metaphorically absent. You understand that? For example, not a display item. That's a case of salam. You notice all the things go to salam? Type. So we have maybe a phone. Let's say you have this phone. What Maulana is saying is that when I tell you, I sell you this phone is physically present, but it's metaphorically absent. Why? Let's read. In times gone by, our scholars would say, a description of the commodity is not sufficient, even if it is extensive, because there are subtle details beyond the description that cannot be known except through viewing. So this is pre-industrial times. Pre-industrial revolution, everything was handmade. Therefore, the fungibility of a product was not precise. What do we mean fungibility? The fact that you can make two of the exact same products was not as common pre-industrial revolution. Therefore, even if you describe the product, the scholars would stipulate that the product must be seen, because there are certain qualities that cannot be known except through seeing it. Make sense? Mala says, undoubtedly, this statement is correct in relation to the past. However, with many of our modern day products, the opposite is true. That is to say, viewing is not sufficient because there are subtle details beyond viewing that cannot be known except through description. And Allah knows best. We also acknowledge that this may differ according to the intent of the buyer, in that he may purchase a product for its shell and not its contents, or be pleased with it and say, I will buy it as is. So what's Mawlana saying? Mawlana is saying that when we look at the Shafi'i madhab in this regard, classically, it would refer mostly to the writings being done pre-industrial times. And that would mean that if you saw something, it was what it was. However, today, a fungible product is made, a product that can be reproduced. When I look at it, it's not what it is. Why? Because beyond this, there's something that I cannot know except if it's described. How many gigabytes is it? How many pixels is the camera? Right? So that I cannot know by looking at it. Any techno geeks, to use the word, yeah, that can belie that statement? Or is that the case? Is it true? Right? So over here, this is an augmentation of the madhab. So we'll see what it is. So I'm going to read something because it's very important, and when we used to read this with Maulana, then he used to stress this point a lot. As for quantity, so we're going to move on to quantity. The same ruling applies to the quantity of the contracted item. It is thus impermissible for you to say, for example, I sell to you a few phones for what you deem a suitable price. Isn't it so? Yeah, give me whatever you want to. This phenomenon occurs frequently within our circles. If you find that amazing, then what is more amazing is that when you set out to advise this contracting party to specify the asking price, he will refuse and say, are we not brothers who trust one another? So, he considers not specifying and asking a price as part of brotherhood, whilst the Sharia considered not specifying a price to be of those things which sever the ties of brotherhood. Right? And students constantly complain about the difficulty they face in implementing these rulings amongst ourselves as Muslims, in addition to experiencing extreme inconvenience. To such students, I say, firstly, the consequences of an invalid contract is more inconvenient. Secondly, Allah does not burden a soul beyond its capacity, and Allah knows best. What's Maulana saying here? Something that happens commonly is the fact that you want to enter into a sale, then the person becomes shy to specify a price. Why? Because we're good friends. No, if you want to give me, inshallah, don't worry. It's fine. Right? Then the person comes and he gives you 1,000 rands, and then you think, Sawa bro. Right? So what you consider to be friendship severs the ties of friendship. That's why there's a book by Mawlana, I think it's Mawlana Ashraf Ali Tanvi. What does he say? Live like brothers, deal like strangers. You know the book? Live like brothers, deal like strangers. Right? So, brotherhood is secured by a person maintaining the laws of Allah subhanahu wa ta'ala. La ghayr, nothing else. A conclusion of the fifth condition. And I'm going to read this now because it's very interesting. And then, we still have 10 minutes and then we'll get into Salam. From what has preceded, you know, O noble student, that the essence, attributes, and quantity of the contracted item must be known. Knowledge is an open-ended word. That is, a word that denotes numerous meanings, not at the same time, but being used in one sense or the other. Accordingly, knowledge can mean seeing, as they say, just as it may denote rational perception or understanding. So when we look at what Mawlana is saying, we say the person must have ilm, they must have knowledge of the contracted item. The word knowledge can mean that they must see it, and that means they know, or they must see it in their mind, in that they understand what it is through a description. Our Shafi'i scholars use the word knowledge to mean seeing. Accordingly, what is meant by the contracted item being known is that it be seen. After selecting this meaning for knowledge, they committed to its usage and the implementations and implications thereof. So, as long as the contracted item is seen, the sale is deemed valid, even if the contracting parties do not know the exact quantity of the product or price. What follows from this is that if you were to say, I buy this phone for you for the money that is in my hand, whilst the seller can see the money, the Shafi'i scholars would permit it, though considering it makruh, deeming viewing the money as sufficient. So if I have a wad of cash, you know what the wad of cash is? Right? So I have a wad of cash in my hand. If I keep this wad of cash in my hand and I tell you that I buy that phone from you for this wad of cash, and you say, I accept, that sale will be valid even if you didn't count the money. Why? Because you can see it. Because you can see it. So, but the sale will be makruh. What is better, according to me, this is the opinion now of Ml Muhammad Carr, what is better, according to me, is that we adopt the second meaning, which is rational perception or understanding, or that we add the second meaning, rational perception, to the first meaning, which is viewing. By this means, we would have taken a healthy precaution and added positively to viewing, which is, God willingly, a worthy addition. Owing to many people being duped in our marketplaces because of sufficing with viewing a product without knowing its reality and attributes. So that's a separate point. So what's Mawlana saying? Mawlana is saying that the madhab, the Shafi'i madhab will say that you must have knowledge. They will select seeing as a meaning of knowledge. And whatever implications that comes with, they will go with it. Right? So Mawlana is saying what? That in our time, we will have to augment the madhab and say that originally the madhab selected knowledge. And then this word knowledge had possibilities in terms of meaning. They selected one possibility and they built the fiqh on that. So what are we saying? We're saying that we are backtracking from the selection of that possibility and we are selecting one of its original meanings by saying knowledge because the nature of goods have changed. You understand that? Allah. So this is deep madhaibal stuff here that Mawlana is doing. So we'll answer the question. We'll answer the question after the class. We can ask it again. Right? So you understand this point that Mawlana is making here? It's a bit of a, maybe the Shafi'i students can appreciate this point. Owing to many people being duped in our marketplaces because of sufficing with viewing a product without knowing its reality and attributes, the Consumer Protection Act, number 64 of 2008, obligates the seller to place a label on certain products, which informs of its ingredients, its contents, so that the buyer can have complete knowledge of what it contains. Similarly, O noble student, with advancements in production and increased complexity of products, viewing has nearly no benefit without describing the the contents of the product. For example, a laptop. It is thus befitting to supplement viewing with a rational perception or understanding. So, when the rational perception takes place through the contracting party seeing the contracted item, the sale is valid. Whether this perception takes place through seeing the entire contracted item or a portion of a fungible item or through viewing along with the description. You understand that? This is that what? When you see something and through seeing it, you know what it is, you can sell it and it's valid. If you see it and you cannot know what it is through seeing it, like a laptop, you need to know what's the processing power, speed, RAM, right? Then that must be described, right? If you can know what it is by looking at half of the product and a description, then you can do that. You understand? Whatever is going to give a person knowledge. The Shafi'is themselves are compelled, in my opinion, to accept what we opine in terms of taking into consideration rational perception for the sale of that which naturally cannot be seen. Example, the sale of eggs. Then, and what has been mentioned, that there are few new attributes of products, such as food being organic or inorganic, that cannot be known except through being verbally explained or written in the product label. So he says there are other products which, if you don't say what it is, you won't know, organic eggs or not. You understand that? Now, so Mawlana says that the Shafi'is are compelled to accept this argument, but they don't necessarily. For example, our other great Shafi'i teacher, Sayyid Ahmad Al-Kaf, he says if you see it, you can sell it. Laptop, whether it is or not. Muhammad Carr says no. If we look at the principles of the Shafi'i madhab, then the Shafi'is shouldn't accept this sale. Mawlana says no. If you read the texts of the Shafi'i, so say it says what? If you read the text of the Shafi'i madhab, it's going to tell you what? That you can sell the laptop without telling you how much RAM it has. Right? Mawlana Muhammad Carr saying no. That's not the madhab. If you go back to the principles of the madhab, then we are saying that seeing was selected on account of the nature of goods at that time. But the actual specification was that of knowledge. And we selected seeing as a vehicle for knowledge. So post-industrial revolution, we need a new vehicle for knowledge. You understand that? Now, last 5 minutes, right? So in the last 5 minutes, we want to say this. That lastly, O honorable reader, we speak about forward buying as a substitute for conventional sale. So forward buying is a contract that we're not going to study in detail. But essentially what forward buying is that when you sell something that doesn't exist or you don't own it at the time when you're selling it. Didn't we say that was invalid? Yeah. So over here, when you sold a fuduli, sells something that exists but he doesn't own it. He has it physically in his hand, but he doesn't own it. A forward buying sale is when a person doesn't have something physically, they don't own it, they're describing it, and then they sell it. You understand that? So another term for this, which is disputed, is called bay'u shay'in mawsufun fi dhimmati. To sell something which is described and that description sits in the seat of responsibility in a person's mind. Right? So many of the Shafi'i scholars will go to say that salam and bay'u shay'in mawsufun fi dhimmati are two separate contracts, and they've delineated 5 differences between them. Other scholars say no, they're the same thing. Whatever it is, we look at salam, and salam will tell us what? That I can sell something that I don't have under specific conditions. Number 1, the thing must be accurately described. Number 2, the thing must be fungible. What do we mean that it must be fungible? We mean that you cannot sell an antique in this manner. Why? Because if it breaks, you cannot produce the likes of it. You understand that? So the item must be fungible in that if it breaks or if it gets perished, then the seller can produce another one. You understand that? So this is the salam contract. Then the price must be squared cash. Salam cannot take place credit. You understand that? So you have to pay cash for the salam product. You understand that? When it comes to bay'u shay'in mawsufun fi dhimmati, then they say that the price must be specified. But when they mean specified here, they mean that you must physically see it and say, this money. Not that both of the products cannot be described. One of them must be physically present. You understand that? And make sense? طيب. So this is a salam contract. That make sense? So what do we mean by specified? We mean that I have this, okay, let's see. So let's say that I have this 50 rands, right? And I want to buy from you a book. So you tell me the book, the publishing, the print, whatever, right? Then I tell you, okay, I buy that book from you for this 50 rands. You understand that? I can't tell you, I buy that book from you for 50 rands. Right? So the price must be specified in the gathering and it must be handed over in the gathering. You understand it? Otherwise it won't be valid.
This is when somebody is not putting something for sale, you're offering purchase.
Either or. Right? Does that make sense? So then the product will come later. The product will come later, right? Then the delivery of that product and other things will have to be specified as well. Are you going to deliver it? Must I come fetch it? All of those things must be specified. You understand? So that's salam. That's salam, right? In detail. There might be other specifics that I have not mentioned, but I've given you enough to be able to conceive of the idea of salam because we're not getting into the chapter now. So knowing that, we read what Maulana says. Lastly, honorable reader, in the agrarian society, you know what the agrarian society is? A society which its economy is based on farming and the like. Right? On? Not barter. In the agrarian society, in times gone by, most products were handmade. Handmade products being such that each item differs from the next. In this context, specifying the exact contracted item was of extreme importance. In our present age, in which the production of most items and products are machine-made, specifying the exact contracted item has become of less importance. This is because products, given that they are machine-made, have become fungible after previously having been non-fungible. The fungible item is such that the likes of it can be produced when it is damaged, destroyed, or not available in a particular store. And one is not bothered by this. For example, when you buy a fridge from a particular store, you see it on the sales floor and are pleased with it. Then you pay for it and the fridge will be delivered to your home or you will collect it from the storehouse or the depot. Whatever the case may be, the fridge that is delivered to your house or you collect from the storage of the store is not the self-same fridge that you saw in the store. At the same time, you are not bothered because it is in fact the fridge that you want. It is in fact the fridge that you want. You consider this to be a normal sale. However, from the lens of the Sharia, it is a forward buying sale, as you will see in the chapter of forward buying. That's why I explained forward buying to you now, right? Most transactions which occur on online trading sites are of this nature. Even though we call them sales, they are only valid as forward buying sales. Make sense? So when you order on Take a Lot, you're not involved in a conventional sale. You're involved in a forward buying sale. That's why you cannot, even conventionally, you cannot buy something online without paying for it immediately. You understand that? Whether you're paying with a credit card or a cash card or a debit card, according to the person receiving the money, it's all the same. According to you, you're going to square it with your bank later. But for them, they're getting it immediately. The payment is made immediately. You understand that? Fine. So, what did we say today? We discussed many things. Right? So, we moved on to the contracted item, and we reminded ourselves that the contracted item firstly must be pure. Thereafter, we said that the contracted item must have a benefit, right? Then we said that that benefit must have, must exist physically, right? If the benefit can only be accessed in a certain quantity, it can only be sold from that quantity and more. Then when we look at the benefit and it exists physically, then, or it's tangible, then we have to survey if the Sharia allows us to access that benefit. If the Sharia allows us to access it, we can sell that product. If not, then not. Then we said that the contracted item must have the possibility of being handed over, right? And we explained what that means. Then we said that the contracted item must belong to the one who is selling it or the one on behalf of whom he is selling. Then we said that the contracting parties must have knowledge of the contracted item, both in terms of the corporeal, its specifications, and its quantity. Right? Then we said that when we look at most sales, then those sales, even though they seem like conventional sales, we actually construe them as forward buying sales, and they are valid in that way. And that's what we discussed today. Tomorrow we will speak about, is it possible for the contracted item to be a usufruct and not a corporeal? And then after that, we'll go straight into riba, and we'll get a little bit into the history of money, and we'll speak a little bit about currency, and we'll give our fatwa on forex, etc., etc., etc. Right? So, naktafi bihada, and then we're open for questions, inshallah.